when someone's exhausted all of their remedies in terms of doing an appeal with Lincoln Financial following a long-term disability denial, as we've talked about in other videos, it can be one appeal or it could have been the mandatory 2 appeals that Lincoln requires. The only remaining remedy is a lawsuit. And that lawsuit, as you guys know, has to be filed in federal court because it's a policy governed by ERISA. And about, I would say, probably 99% of what Lincoln Financial sells is group disability policies, which are governed by ERISA. I rarely see something that's exempt by ERISA that they sell, although it could be a product that's out there if they sold it to an association or something like that where you're not an employee. So we'll focus this on being an ERISA lawsuit if you've been denied your long-term disability benefits by Lincoln. Caesar, when you get this call or you do an appeal and it's to file a lawsuit against Lincoln Financial, what are you thinking you're going to be up against in terms of trying to win benefits for the claimant?
Well, I know that Lincoln is going to attempt to take a pretty strong stance on their position. I think it's on our part, we have to be very confident in terms of the points that we're going to be arguing, the reasons that we're going to be now going into litigation. Because if you're showing them that you are you're weak or that you're not willing to kind of go into those next stages, then they're probably going to not feel as feel as if they have as much exposure, as much risk on their end. But I could tell you that oftentimes, even before we get to the point where we're really heavy into litigation with Lincoln, there may come the opportunity to try to resolve the claim with them or the case with them. The legal side and the business administrative side is different from the claim side, and that's what some people don't really understand, but that's what we understand. That's what we deal with every day. And probably soon after that lawsuit, we'll be engaging in these types of discussions with either their defense counsel or with the counsel that's managing the case out of their home office. And again, you have to reflect and represent that you're coming from a strong position. You filed this lawsuit because you firmly believe it's got merit, that your client's been wronged. And I think that's what you really need to project when you approach them.
So Alex, we talk about challenges in ERISA disability lawsuits, and it's not just specific to Lincoln, it applies to all of them. But what makes this ERISA lawsuit so different than what every person who's not a lawyer thinks about when they see a lawsuit on television or they watch a lawsuit in the media? Because this is not that. It's completely different. Can you explain what a person should expect when a Lincoln Financial lawsuit's filed?
So you would think that we file your lawsuit as a claimant, and someone in the claimant shoes, that they're going to have their day in court, where they get up in front of the judge and testify and say, "Judge, this is all I'm going through. I'm in so much pain." And you cry. You walk inside courtroom. Maybe you're rolled in a wheelchair. You have a cane when you walk in. You'll never have that day in court under ERISA. It's typically a trial on the papers. So the judge will have the written arguments from the attorneys, sometimes verbal arguments, not as often, but sometimes verbal arguments. No testimony whatsoever. Your doctor cannot come in and testify. The judge just reviews the papers, that claim file that we discussed earlier, and ultimately renders a decision. Now, you would think, watching TV or just thinking logically, that if I prove to the judge that I'm disabled from my own occupation or any occupation, the judge is going to rule in my favor and award me, put me back on claim, right? Under ERISA, not so quick, okay? Doesn't happen that way. Most of these policies have what's known as discretionary clauses, and that gives the discretion to the insurance company to interpret the policies and render a decision on the evidence that has been submitted in support or against this claim. And if your policy has a discretionary clause, as most of these Lincoln policies do have, then in order for you to prevail at court, not only do you have to prove to the judge that you are disabled under the terms of the policy, but then for you to win, you have to prove that Lincoln rendered an unreasonable decision in denying your claim. Arbitrary and capricious is the standard. Very hard to beat arbitrary and capricious standard. I think it's the highest level of judicial review out there. If it was no arbitrary and capricious standard, it'd be a de novo review. Then if you prove to the judge that you are disabled, you win. Under ERISA, it doesn't work that way. Unfortunately, you have to prove that their decision was arbitrary and capricious. And that's going back to our appeal. That's why your appeal is so important to get every single piece of evidence in that claim file, because if you don't have it in there, then you're going to be up against a lot. You're going to be up against not only bad evidence, also, bad laws that really do protect the insurance companies under ERISA.
You guys know people hire us either if we've done their appeal and then we file a lawsuit if the appeal wasn't successful, or many people call us and say, whoever did their appeal, I want you to handle my, my lawsuit for me. And we do talk a lot about, and we have tons of video, and you'll read if you put in ERISA laws or ERISA disability, how it's not necessarily fair to claimants. And because of this discretionary clause, which gives discretion to the that the judge has to defer to the insurance company. But the reality is, and we've talked about this many times because we've all read thousands and thousands of ERISA opinions, I have almost never seen an opinion that comes down from an ERISA judge that says, I believe the claimant is disabled. I've reviewed all the medical records because that's the first thing the judge has to do no matter what. I've never seen an opinion where the judge goes, this person I think is disabled. However, the law makes me say that if you acted reasonable in your review, then I can't overturn the decision. I don't see it happen. And if it is out there, I just haven't seen it and someone can prove me wrong because it's an anomaly. My point with that is that these judges bring their personal experiences to the matter. And if they're looking at it and going, I reviewed everything, you're disabled, then the next thing they're going to say is, how did this insurance company, Lincoln Financial, find that they're not disabled? I looked at the same exact information in the same exact way that appeals claim rep was supposed to look at it, yet they found that you're not disabled, and me, the judge, I'm finding you are disabled. So judge has to deal with that and come back and then look. And I believe that every judge, if it's presented to them, and this is where it gets into that trial on the papers, and the judge reviews the records to say, Judge, if you think this person's disabled, then obviously they did something unreasonable in their review, because you're supposed to be the arbitrator of fact, the most reasonable one in the country to review this. So how did you get there and they didn't? And that's why I think no matter what we hear about this arbitrary and capricious standard, and this is an argument we always make, you guys know, when we're mediating these cases, which we'll talk about in a minute, to say, you guys can jump up and down and tell us about your standard review, but you know what I say to them? I don't care. I think that's nonsense. I think it's a level playing field for the claimant, slightly level. And we're going to convince this judge otherwise. And we're going to do it because this case supports them and that case supports them, and you miss this fact and that fact and everything else that we do. So I want to give the claimants hope with this thing, but they're going to hear from a lot of people about how bad this ERISA is. And it does skew towards the insurance company, but there is hope. You can convince the judge, but you really got to reach deep into the facts and really, really know the case law out there to bring those cases to support your arguments. Now, Caesar, what are the remedies? Because everyone thinks, okay, I'm filing a lawsuit, but what can you win? What is a win? Because we advertise and we tell people we win 99% of our Lincoln Financial ERISA disability cases, but how do you define a win? What are the ways to win?
So, I mean, the most obvious way, right, is you either win your appeal or you win your federal case to recover your benefits from the disability plan, and what you receive, what you win, are the benefits that have been owed since either they stop paying or from the onset of your disability claim. Okay, and that's what you win. That's what ERISA, when they wrote this in their eminent wisdom, and Congress, wrote the legislation, they said, this is what we're writing in terms of what the recovery of damages are. There's a section about attorney's fees. There's the ability to recover attorney's fees only in the actual lawsuit, not in the appeal, not in the second level of appeal if you have one, with Lincoln, only if you win your lawsuit. And that could be a two-way street in the sense that, it goes to the party that wins on the merits, right? Success on the merits. So that's what you can potentially receive. Do I get asked, I've defaulted on my mortgage. I've had to borrow money from, my siblings. I've, lost in, being able to invest in, my 401k, continue investing in my 401k, or a lot of things. My health insurance benefits have been cut off. So many things could potentially catastrophically happen as a result of Lincoln's failure to, pay your benefits and for violating the terms of the policy, but you can only recover those benefits that you're owed. So that's one way of succeeding, right? Winning those benefits.
And by the way, if you win at court, do they have to pay you the rest of your life, or how long?
So, again, this all kind of falls within the discretion of the court. What have they decided based on the briefs that have been done and the evidence that's presented? What's the judge decided? Perhaps he's said, well, really, there's only evidence supporting up to this point. And so I'm awarding benefits up to this, but after this, no benefits. Or I'm remanding it back to Lincoln to further decide whether they're eligible for benefits after this point. Or they could say, I think that I'm not even going to look at the question of whether they're disabled because I think Lincoln made a really, bad error here. They didn't give them an opportunity to respond to this peer review within a timely manner or something. And so I'm remanding it, sending it back to Lincoln to give them sufficient time to adequately respond to this peer review report or whatever this additional piece of evidence. So really the court's got some broad range in terms of, what they could do that could potentially benefit the claimant.
So you never can win future benefits in these things. The judge can't say, oh, I'm going to pay you for the next 10 years because you just get back on claim, put where you were, or if you never got paid, you get back benefits, and then you got to move forward and submit to them every month. Mm-hmm. But you guys also know that 99% of these cases resolve in what's called a lump sum settlement. And the court, once you file in federal court, no matter what kind of case it is, requires you to go to mediation. And the courts are always trying to push the two parties to come together and reach an agreement because there's no guarantees in terms of who's going to win. And what happens in these Lincoln Financial ERISA suits is that if we believe in your case and think your case has merits, we can guarantee we're going to get an offer. I mean, there's no doubt about it. I've never taken a case, I know none of you guys have, where unless the person committed fraud, there's going to be an offer. Because as much as there's a chance that you could win the case, there's a chance that they could lose the case, the insurance company. And they know that. So the nature of how this works out is that an offer is going to be made on your case for a certain dollar amount because there's a finite amount for this policy. If you're age 55 and you're getting $100,000 a year and you got 10 years left, we know the case is worth $1 million discounted for present value, which means how much money is $1 million 10 years from now. And they offer you a percentage. And they take into consideration, what is that percentage? It can be anywhere from 10 cents to 60 cents. It depends. Sometimes 80%. It really just depends if you have an exceptional case where they know they're going to lose. But they don't usually pay that much because the disability insurance company would rather just say, you know what, we'll put you back on claim and maybe you get better. Maybe you don't live. Maybe we go out of business. There's no guarantee. So that's the scenarios that people have to think. But the bottom line is when we talk about wins, when I asked you, Caesar, a win can be you resolve the case at, you win. You absolutely just win and the judge says you're awarded. Or a win could be you get a lump sum settlement and you walk away with money. What's a loss? You walk away with absolutely nothing and potentially have to pay their attorney's fees. So these are all things when people call us that we'll discuss and go through and look at it and let you know immediately if we think you have a case that we can win. And we always offer a free consultation. So we encourage claimants call us. We can review it, set an appointment right away, spend as much time as you need. We don't charge any fees or costs unless we win your case. So no matter where you live in the country, give us a call. We look forward to speaking with you.